Good afternoon, everyone, and thank you all for being present here today for the webinar session. The topic for today's webinar is Employment and Workplace Safety in the Maritime Sector with Multi-Jurisdictional Challenges. It deals with POSH, harassment, prevention, and inclusion for shore and ship. And the speaker for today's topic is our very own WISTA member, Advocate S. Priya, who many of you might know as one of the unofficial legal advisors of WISTA India. With over 3 decades in the maritime legal field, international trade laws, and related areas, she has a wealth of experience and insight. We are deeply grateful that despite her incredibly busy schedule this week, she has taken the time to be with us today to speak on this very relevant and timely topic as more and more women continue to participate in the maritime sector and continue to grow in the maritime workforce. Priya, it's a pleasure to have you with us today. Over to you.
Thank you, Jimmy, and thank you for the very kind introduction. Uh, yes, what can I say? But yes, let's get on to the topic. Like you said, it's a very interesting topic. It's more about how we see more and more women join the maritime workforce, and with it, therefore, the need to understand how safety has now to be construed in the real life workplace insofar as the new setup is concerned. And so let's look at that in terms of multi-jurisdictional challenges. uh, how do you deal with POSH, particularly when you come to situations involving more than one legal jurisdiction, more than one legal situation, about harassment prevention, and how do you deal with shore and ship harassment policies, how do companies implement them, etc. Previously, when we used to talk about workplace safety, particularly in the maritime sector, the first image that comes to mind are the helmets, the harnesses, the firefighting drills, and the boots. That's a thing of the past. That's no longer just the meaning of safety as we see it today. The modern definition of safety is far more broader, deeper, complex. It's about the complete well being of every person who works on or around ships. It includes not only physical protection from harm, it also includes psychological security. It includes the most important concept of dignity at work. It includes freedom from harassment and discrimination. If I could define it very simply, I would say it's a right to work without any fear. What makes our industry, the maritime industry, so unique, and if I could call it that, so complex, is that it operates across jurisdiction, it operates across time zones, and it operates across multiple legal systems. Ships, in that sense, in the context of what we are talking today, are the floating workplaces. Since we are talking about POSH, which deals with workplace harassment, ships in that sense are the floating workplaces, and ships are governed by the laws of the flag that they fly intrinsically. These ships are subject to port state inspection wherever they call at different ports, and therefore are subject to those laws as well. They are manned by multinational crews. They are managed by companies based across multiple jurisdictions. And it is in situations like this that the implementation of the workplace safety standards, particularly in areas like harassment prevention, gender inclusivity, both essential but also challenging. In this backdrop, I would therefore like to discuss this evolving topic. How does law define safety? How does law apply this across various jurisdictions? How does the POSH framework align with maritime law of each country? And what makes each of us participant, whether it's a ship owner, whether it's an HR professional, whether it's a master or a member of crew, or for that matter, whether it's a regulator, a maritime administrator or a regulator, What is it that we can do to make our workplace, which is either a ship or associated with the ship, the shore jobs, both safe and inclusive for everyone? Like I said, safety at sea, when originally SOLAS was framed, was construed in a very different manner. But over the period of time, all these conventions, whether it is SOLAS, whether it's MARPOL, or for that matter, it is the ISM code, they have all created a very structured culture of physical safety. Yet, for all these years, the psychological well-being, harassment prevention were all treated as very private topic, never deemed to be made part of these conventions. All of this, however, changed with the Maritime Labour Convention, which came in 2006, rightly called as a Seafarers' Bill of Rights. In 2022, there were amendments to the Maritime Labour Convention, formally recognizing that seafarers have a right to a workplace which is free from harassment and bullying. Bullying also, in that sense, falls under the broad heading of harassment. This was therefore not just symbolic. By doing so, at some level, it is deemed to be part of the seaworthiness of the vessel. For flag states, compliance with this requirement is no longer just a legal, it's a legal obligation. It is not a courtesy being offered to a seafarer. The ILO convention, which was introduced sometime in 2019, expanded the definition of workplace safety beyond just physical harm. That's the first time it moved beyond the realm of physical safety. It recognized violence and harassment as unacceptable conduct which causes physical, psychological, sexual, economic harm. And it applied this across all sectors to all workers, including those at sea and at shore. With this, a global shift was gradually being felt where safety now included respect and compliance now included culture, a culture change of culture at work. In India, constitutional foundation for workplace dignity was always provided in our constitution under Article 14, 15, where the equality before law, prohibition on discrimination on the grounds of sex, right to life, personal liberty has all been guaranteed under our constitution. Despite that, there was still harassment in various forms that's being felt, that's continued to be felt today. But the big change in terms of prevention of sexual harassment came from the Supreme Court's landmark decision in the case of Vishaka, which I think by now everybody knows, where the court declared that sexual harassment violates these very constitutional rights. And for the first time, it declared that the employer must create an internal mechanism to redress all these issues. These guidelines eventually were codified into what we now call as the POSH Act. The POSH Act mandates, and I'm going to go into very briefly for the time being, it mandates formation of internal committees which are going to look into this, the procedure by which complaints are to be made, what are the confidential protections that's being afforded to people. It also defines what is a workplace. A very broad definition of workplace is being defined. It includes any place that is visited by an employee arising out of and in the course of employment. It's as broad as that. It's not just restricted to the four walls that you would normally clock in and clock out at the end of the day or when you go to work. It includes any place that you're ordinarily required to work. It also includes the transport, if any, that's provided by the employer to reach a workplace. But that's for the shore. For Indian flagged vessels and maritime establishments, POSH obligations actually extend to ships, it extends to port, it extends to maritime training institutes, academies, everything. With this, On paper, the framework is there that there is a right to a safe workplace which is being provided to a seafarer, whether that workplace is an office in Mumbai, it's an office on shore, or whether it is a ship in the middle of the ocean. But is that enough is what we need to then see. Let's first look at very briefly the domestic legislations that we have on the topic, and then we can look at how this whole thing evolved and the background to the evolution. So India framed under the Merchant Shipping Act, India framed the Merchant Shipping Maritime Labor Rules 2016 to give effect to the Maritime Labor Convention, under which it mandated that ship owners must guarantee fair conditions of employment, safe working, living environment, and it should also have access to grievance procedures. Following this and building on this, the DG Shipping then issued Notice number 7 of 2019, which creates a specific structure for handling of sexual harassment and bullying on board Indian flagged vessels. Typically, what does it include? It includes the appointment of a designated officer on board to receive complaints. So if there is any problem on board, every ship is to have a designated officer to whom such complaints are to be addressed. There is a shore-based complaints committee within every RPS or employer with trained members, including women seafarers where possible, to entertain such complaints. There is a guarantee that the complainant's employment or safety will not be prejudiced by their following up and making such a complaint. And there is also a designated person ashore whose job is to ensure follow up and also maintain the confidentiality of such a complaint. These are measures that were introduced to bring POSH principles into the maritime environment. This was also done partially to align India's commitment to the MLC regulations, which require that onboard complaints, the mechanisms are fair, effective, and free from victimization. Now, another thing which could be done, which I'm not so sure is being done so effectively at the time being, is that the Merchant Shipping Act also has procedures for cancellation and suspension of certificates of competencies that are issued to a mariner or a seafarer. This power vests with the DG Shipping under the merchant shipping rules, which are introduced under, I think it's a 2002 or a 2003 regulation. Now, under these, in the event of any misconduct which causes any injury or endangers the safety of the vessel, the DG Shipping is empowered to either suspend or cancel the seafarer's certificate of competency. Harassment is threatening the mental safety or the physical safety of a crew on board a vessel as and when it occurs. And therefore, ideally, it should be applied to such cases. Whether it is today or not is to be seen in the real situation when the question arises. But as of now, I don't see it being applied, but it should be. The provisions are there and it should be applied. So we will see that we do have a compliance structure which is formed through which complaint, when made by a victim of sexual harassment or bullying on a ship, is being addressed in a proper manner. But the background to all this and to see how this whole thing developed in the manner it did is the Safer Seas Act of 2022 in the United States. In 2019, there was a US cadet on board a vessel, a foreign flag vessel, who was sexually assaulted by a senior officer while she was serving during her training year. After a period of time, in sometime in June 2022, she filed a suit in the United States against that company. Whilst the outcome of the suit in terms of the litigation itself is not relevant, the matter got settled eventually. But the broader impact of the case is what prompted significant reforms in maritime policies, including the introduction of the Safer Seas Act in 2022. The implementing authority in the United States is the US Coast Guard, and they have implemented statutory requirements aimed at enhancing crew safety in the maritime industry to the extent of eliminating sexual assault and harassment. I dwell on this with some detail because I think these are the key policies which every stakeholder must bear in mind when either framing policies within their organization, or for that matter, a seafarer must bear in mind if they are ever subject to any such incident while they are on board a ship. Some of the key things that have been implemented by the US Safeguard, the US Coast Guard, are about the information awareness, where the company policies and procedures for reporting of complaints must be prominently displayed in crew rest areas and washrooms. That's important. Two, something that's being implemented world over today is vessels must install video and audio surveillance near the crew cabins, retaining this footage for a mandatory period of time so that inspections can be done from time to time. Very important is crew training, which is mandatory for reporting and responding to such assaults or harassment instances. Another important thing that was noticed was the use or unauthorized use of master key. Strict procedures were put in place for use of the master keys on board the vessels, where an unauthorized use of such a master key carried a civil penalty, as well as the potential suspension and revocation of their master's ticket or their equivalent of certificate of competency. There is also a safety management system inclusion, which provides for an annual training and procedure for reporting, documentation, and investigation of incident. More often than not, we have in place a proper procedure for reporting. What happens after that? Are the persons to whom the reporting made, do they have the ability to properly conduct the investigation? What are the key guidelines for conduct of investigation? How should one document the entire investigation process and or the outcome? Now, these are not things that are necessarily also taught. So the US Coast Guard included a training for clearly training the person who's going to be dealing with this to deal with it in a proper manner. Mandatory reporting. Ship owners, masters, vessel operators, employers are all now required to forward or report all the complaints to the United States Coast Guard on a mandated system. A failure to report also includes a hefty civil penalty. In addition to mandatory reporting, there is also follow-up reporting, which requires that once the reporting is made, within 10 days, a follow-up report is also to be submitted, detailing what all actions have been taken by the company till date to rectify the situation, address the situation, etc. And importantly, under their Safer Seas Act and all the notifications issued thereunder, where there is an instance of proven misconduct of an officer, these are taken to be grounds for suspension and revocation of license. So this is one of the key things that was introduced, which actually instills a clear deterrent to such instances being done in future. The Safer Seas Act demonstrated that when it comes down to maritime safety frameworks, it can clearly be set up quickly across globe, across jurisdictions, when dignity is treated as integral to safety. Our own 2019 guidelines mirror some of these reforms. It sets out the complaint channels, non-retaliation clauses. How does the shore oversight officers monitor the entire situation? In a sense, it proves that there is a possibility of a global convergence on topics like this, even if two countries did not have identical legislations or, for that matter, thought process, social setup. Even when all of this are different on these key issues, it is possible to have a global conversion. But then why is this so much of a challenge, unlike in a shore-based job? The maritime sector itself functions across overlapping legal jurisdictions. A ship can be owned in, say, one country, which is in one part of the globe. It's managed, technically managed, commercially managed, crew managed by two, three different entities spread out in different parts of the globe. It may be bareboat chartered to somebody. So there is someone else who is also equally in charge of the vessel. The crew on board the ship may at any given point of time be belonging to citizens of more than one jurisdiction. So when a harassment instance happens, the question comes that which law is applicable. And this question is actually, it's an issue. It's far more than academic. Under the Maritime Labour Convention, and under international laws, the primary responsibility always remains that of the flag state. It is also the flag state which has the primary responsibility to enforce labor standards on the vessel. Vessel calls at port on the course of their voyages. Port states have their own port state control. They can inspect and detain ships for any violations under their port state regimes. The seafarer's home country has their own set of laws, and the seafarer can also seek protection against that law or the support that he gets there. The employer or the bareboat charterer or whichever jurisdiction that he is, that country would have its own set of regulations. And they also form part of this complex legal system to which this one incident is subject to. When it comes to any other technical compliance matters, such a multi-layered system could be very effective because you have multi-layers, multi-level check and balance in place. But when it comes down to addressing a seafarer's grievance for harassment, it can actually get complex, or for that matter, it can get very confusing. A seafarer sometimes may have to navigate different jurisdictions for seeking justice. Any complaint of sexual harassment or bullying that's made on a ship will be subject to a flag state investigation. It's subject to a port state inquiry. It can be subject to civil proceedings in the employer's country. It can also be subject to criminal proceeding in the offender's home country. There are multiple jurisdictions at play here. If I can just give a quick example for ease of understanding, we may have a Panamanian flagged vessel. This Panamanian flagged vessel is technically managed by a Hong Kong-based company. It's crew managed by a Singapore company. The crew on board belong to, say, India, Philippines, and Singapore nationality. assuming that for the moment, since just for this, for the purpose of this webinar, since we're doing it in India, assume that the person who is made a subject of sexual harassment is an Indian, and the offender is a person who's not of Indian jurisdiction. It could be any foreigner. Any complaint that's made for this necessarily has to be reported to Panama. It would necessarily be reported to the crewing contractor, which is a Singapore company. Now in India, because the Singapore company cannot directly employ employ the seafarer, you necessarily have an Indian RPS agent. So you have an Indian RPS also who has their own procedure at stake. You then have the Indian seafarer who has the protection of the Merchant Shipping Act. And there is an offender who is subject to a foreign law. So you have that jurisdiction as well. Now, with so many legal jurisdictions at play, legal frameworks at play, one needs to have a practical solution as to how this is to be dealt with. In my opinion, one of the simplest way to deal with it is to have a clear contractual clause. A harassment complaint, in addition to being also a matter of criminal complaint, can also be a subject of, say, a mediation. It can be subject of arbitration. It could be subject of a company intervention as well. So having a clear contractual clause in the employment agreement specifying that in such an event, this is the route to be followed, this is the governing law, and this is the dispute resolution mechanism to be followed, may offer a quick solution to a seafarer in such a situation, instead of having to go from jurisdiction to jurisdiction, trying to find a redressal to this issue. It will also ensure that shipowners would also maintain shore-based POSH compliant committee accessible via digital media. So there is a requirement to have a shore-based complaint mechanism. The seafarer is on the ship for most of the time during the year and may not find enough time at the end of the voyage or during his or her break to go before the shore-based committee to give their complaints. It may also delay the process. So there should be digital reporting. There should also be digital adjudication. Today, it's perfectly possible to do all of that. Digital channels are meant to ease these problems which are caused by multi-jurisdictional challenges. They are able to give us immediate resolution, maybe a short-term resolution, whilst of course keeping the option open for the seafarer to explore any other legal proceedings that they may eventually consider. But at least there is an access to an immediate redressal system. All of this today has led to an increased discussions amongst maritime stakeholders for a mutual assistance protocol between flag states to share information for a better flow of information, for better ways and means to address these issues, akin to what is being done in port state control matters. Now, this is one part of the legal redressal of the issue. But another way to address this whole thing is to see if the whole culture can be changed, and which is where the shift needs to come from the fact that where compliance is essential, ultimately the shift has to be in the culture. The shift in culture should be the goal. A workplace can have its policies printed, displayed across all platforms, but these policies would not succeed if this is not practiced on a daily basis. Inclusion really begins with very small, tangible steps. It begins with equal access to facility, privacy in accommodation, proper lighting in passageways, balance duty roster, basic language which reflects respect to your co-worker. I remember early on in this topic, I had met someone, a young woman officer who had just joined the ship, and something that I had not even thought of. And when she said that is when it really struck a chord, that how you can have workplace challenges which one doesn't take for granted in our day-to-day life. The woman officer joined the ship, and at that time there were the practice was not to have two women officers. She was a single woman officer on the ship, and for various reasons she was given a cabin which was right at the end of a corridor, right at the end where light is very dim. And every day it meant that she had to walk through that many doors to reach her cabin, and she would feel safe only when she reached there. And that walk was something she had to do maybe twice, maybe four times a day. And it was not, it just was not conducive for mental health. All of that has changed, of course, today. It has changed today, but there is still a lot that can be done. And that is where training really plays a decisive role. Under the ISM code, the companies have established their safety management systems. These safety management systems should integrate POSH and inclusion trainings. This is very important. Gender sensitization is no longer optional. Gender sensitization should be an integral part of training. Just as you would have a routine safety drill or, say, a fire drill, you must have a routine gender sensitization drill, if you could call it that, which should be an integral part of the system. There must be behavioral safety drills. The crew must be given role play based sessions where they can practice in real time as to how to respond to inappropriate conduct. It's not just enough to tell them that you need to respond. It's more than that. It is, you have to give them the ability, show them sometimes how it is done. For this is on ships. For shore establishments, uh, there is an internal committee under the POSH Act who should coordinate with the maritime complaints structure. Uh, there has to be a continuity to this whole thing, so that a seafarer who's made a complaint whilst he was serving on the vessel comes to shore to follow up on the complaint, comes back before the same entity and not a completely different set of body altogether. Inclusivity actually also extends beyond gender. I don't think we need to say too much on that. We're all familiar with that. The modern maritime workflows includes people of multiple nationalities, multiple faith, multiple orientation. A safe place, a safe workplace, or a psychologically safe workplace is one where professional competence and not a personal identity determines respect, demands respect. Respect is integral to this whole subject, and therefore that has to be kept right on top. Now, like I said earlier, you can have policies uh, printed and put on all your boards. It can be distributed across various forums. But these are meaningful only if they are enforced, and they are enforced consistently. Our maritime administration would be the office of the DG Shipping, and as the flag state authority for Indian flag vessels, they have the legal power to ensure that complaint mechanisms work in place by conducting periodic audit under the MLC regime. They can follow up on the anonymous complaints, all of this to be done without breaching confidentiality. Uh, Employers are required to integrate these procedures into their SMS, that is safety management systems. have them verified during their document of compliance audit. In fact, very many of the PNI clubs have also begun requiring evidence of such systems as a part of their risk assessment. The requirement of this robust anti-harassment framework is actually now an indicator of how the company treats this subject and their reliability on this topic. But with all this, despite so much of progress that is made, there are several gaps that still exist. Like I mentioned earlier, in a multi-jurisdictional complaint issue, the legal recourse path is fragmented, to say the least. So there is an Indian seafarer on a foreign flag vessel facing harassment from a foreign crew. The vessel is owned by a foreign ship owner. It's managed by a foreign technical manager. Where does the seafarer go to? When the seafarer is spending so much time at sea and is home for a short period of time, the legal framework is time consuming. And more often than not, the seafarer is uh, deterred in carrying forward this complaint simply because of lack of time. In such cases, it's very important for maritime stakeholders, whether it is the flag state countries, port state control, whether it is countries to which the crew belong, all of them to enter into cooperation agreement, bilateral, multilateral cooperation agreement to ensure that there is speedy recourse and remedies in such a situation. Second thing is, of course, like I said earlier, the need for digitization. There is a lot of it which is already present today. Most of the companies today do have a proper POSH guideline, including a reporting pattern, whether they are on ships or they are on shore, etc. While that is there, there is also a requirement to add more digitization into this to ensure that there are time zone flexible hearings also that are conducted even before the uh, before the seafarer or the offender are asked to get off the ship and come back to their respective country for investigations, etc. There should be investigations which are also held while they are on the ship. There are remote investigation models which are there, which can be put into place. All of these are required to be taken on a war footing basis. And there should be no time gap or delay in the implementation of this. And third, of course, is there is what I would call as cultural inertia. The law gives you the power, it gives you the uh, it gives you the tools to enforce compliance, but it cannot train you to be empathetic to the situation. This can only be cultivated through training, through leadership behavior, through peer accountability, and like I said, role play situations, anything. Even the leadership needs to take charge and understand there is the requirement to be aware of these issues and the need for a timely redressal. Therefore, if I could sum it up for organizations as to what they could do going forward for such situations, particularly in the light of the multi-jurisdictional challenges that is faced, is ensure that all the POSH requirements, which every company today in India is required to anyway have under the Companies Act, these POSH requirements should be included and integrated into your ISM manuals. It should be a part of your internal audit. It should be a part of your check and balance system. It should be a part of the company not waiting for a member, a crew member, or a shore staff to come forward with a complaint. There must be a check and balance system for such reportings to take place seamlessly. Of course, establish a robust onboard as well as an onshore complaint mechanism, channel system, as you call it, which can function seamlessly across different time zones. It should not be that the vessel is on the other side of the globe and the reporting channel is functional only during India working hours, which is 10 to 5. It beats the purpose if the person does not have access to a complaint system. You have technology at your disposal today, all kinds of helplines, WhatsApp, confidential channel chats, a lot of technology is available, including for communicating with ships. All of that must be used. The companies must be able to, how do you call it? The HR should be able to integrate it seamlessly, should be able to update it from time to time, train everybody in the organization, whether it is a master of the vessel or any of the crew members, whether it is designated persons on shore, whether it's your HR department, whether it is welfare department, or for that matter, it is the company senior management. Train everybody to be aware of this, because it is only the training which is going to bring about that culture in the company, not just the compliance. Conduct routine workplace safety audits, which includes routine audits on lighting. Like I said, dim lit lightings are a safety issue, accommodation, privacy aspects. Uh, Ensure that your employment contracts do contain dispute resolution mechanisms. It contains provisions relating to applicable law, etc. Where it is possible, and that's the timely need of the hour, is to link a disciplinary action to the certification of the seafarer. Because where employment or your work is at stake, to some extent, the deterrent does come into place. And of course, promote uh, gender inclusion initiatives, not just gender inclusion, all inclusion initiatives within the company. All of this, when taken together, will transform that company from being a compliance checkbox into a culture which is then easy to carry forward, a culture that is then does not require compliance, but a culture that requires maintaining, which in the long run is far more healthier. Safety and inclusions are not separate goals. According to me, safety includes inclusion. It enhances when there is inclusion in it. When you've got diverse minds at work, they communicate better. When there are so many voices at stake and there is a culture of hearing every voice, there are fewer mistakes that go unnoticed because some or the other voice are bound to point it out. The future of uh, maritime employment, in my opinion, will be judged not by how efficiently we are working on the ship, how efficiently we move cargo, but I think it goes back to something very basic as to how responsibly we treat people. A sea can be unpredictable. The workplace should never be. It must be a safe place. And therefore, a ship should only be considered seaworthy when all who are on board can work and live on it without fear. So that's my take on this, and I'm happy to answer any questions you have.
Thank you, Priya. If anyone would like to ask any questions, please feel free to unmute yourself. Before anyone asks a question, Priya, I just wanted to know, you have mentioned about the cultural inertia, right? So how do you see the inclusion and harassment prevention evolving in the maritime workplace over maybe say the next decade or so?
It is changing. It is changing. That's why I said there was cultural inertia up to a point in time, but there is just so much talk about it going on that today you do find a lot more people open to it. You see the number of women officers going on board definitely increasing. The whole thing, I think, has gained a lot of momentum, and I only see it gathering more momentum in the coming years.
Okay. So it's all for the better, you will say,
It
right?
is getting definitely for the better. It's
Okay.
definitely getting for the better. Is it moving with the speed that it should? But at the moment, my answer is still no. I think it can move still
Right.
faster. But definitely, for example, Vista is playing a huge part in making this topic heard across different platforms. So all of that is making a difference. Possibly, we can move a little bit more faster.
Yes, that's always there. The faster, the better when it comes to
Yeah.
women inclusions and women safety, right?
Yes, yes,
Uh, would
absolutely.
anyone would anyone else like to ask any questions?
I'd like to ask a question.
Yes, please. Yes, Bhagyashri.
Uh, yeah. Hi.
Yes.
Good afternoon, everyone. I just wanted to know that, like on the ships and in the seafaring industry, we see a lot of women coming in, but not a lot of people in the leadership roles. So, what can we do for that?
Did you mean leadership on board ships or on shore?
On board also and on shore also, but basically on board because the numbers, the junior engineers officers you see nowadays, like there's a huge increase in a number of girls in that field. Also, a lot of companies are taking a lot of initiatives to increase the intake of girls, but as we go
Yes.
up the ranks in the top four, I don't see a lot of girls being there or sustaining their positions there. So is there anything that we can do or some solutions that can be brought about for this?
I personally think that yes, there is lesser people than what should be there. But I also think that with the number of women who are now joining the seafaring community, it takes time for all of them to grow up the ladder, and which I see a lot of them doing. So, I believe in the coming years, you will find far more masters or chief engineers who would be women than what is there currently. What can be done to improve this or increase the numbers is, of course, the when the workplace uh, safety environment is created, you will find that a lot more women would be willing to come, because more often than not in the past, that's been one of the primary reasons for them to take a quicker exit from their seafaring career and find onshore jobs. So hopefully with this new culture coming into place in the companies on board ships, within the organizations themselves, you should see some change in the coming years.
Okay, okay. Thank you so much. That
Yeah,
answered my question.
yeah, because you do need time, lead time for all of them to come from the bottom of the rung to the top. So you need to give them the time, and that
Yes.
time is not too
Yes,
far.
yes,
It should happen soon.
yes. I
Yes,
just
I just
sometimes feel, if I may continue,
Sure.
um,
sure, sure.
that sometimes women, when they are in the technical ranks and that jump from technical into management, if at the technical rank only your view or vision is not taken into consideration, then they don't have the confidence to go up to the management role. That's just one
Hmm.
of the observations I had, which
Right.
we
No, you're right.
might need to address.
Yes, absolutely. which is where mentorship comes in, right? Uh, did I mention about that? I don't think I mentioned about mentorship, but mentorship plays a huge role in ensuring that as women are working their way up the ladder and they face with operational challenges, they face with leadership challenges, uh, they would need some hand holding, and that is something that is definitely changing in the coming period.
Yeah, yeah. I think mentorship is really important. Thank
Mentorship
you
is
so
very
much. Thank
important
you.
in this. Yeah, yeah. Thank you.
And Bhagishri, I also wanted to add, we are fairly new. Women are being included, maybe say in the last 5 or 10 years, Priya, if you could
Yeah,
correct me.
yeah.
Yes, so it will take time, like how Priya said, it would take time for us to reach the leadership levels and maybe make a dent in all the
We are.
policy decisions and regulations.
Absolutely.
Yeah,
Yeah. We are making, you do find more officers coming in, you do find more engineers joining, but but Bhagishri has a point. If their
mm,
confidence is not boosted at that stage, would they
true.
have the confidence to carry it up to the next level? And that's where
Right.
the mentorship program comes in. If it's not already there in organizations, then it would be a good thing to also implement that as a part of this whole workplace safety environment, where they are given the necessary support system to
Mm.
grow in the system. Yeah,
Yeah, that's where I guess the Vista associations and all come in with their
yeah,
mentorship programs. Yes.
yes, yes.
Anyone else? Could anyone, would anyone want to ask any other query? All right, then if that is all, I would like Aarti to just say a few words of gratitude. Yes.
Thank you, Jimmy. Hi, Priya. It was lovely, great listening to you. I just had, before I wanted to move into the word of thanks, in this multi jurisdictional aspect, you had explained who would bear the legal costs of it all. Everything is down to cost. So, where do we go for it?
So technically, is a very valid point, Arti, as usual, coming from a ship owner. I should say the owner bears the cost, but yes, who will bear the cost? Um at the first instance, the requirement to provide a safe workplace is that of the owner, and therefore, if there is if such an environment is not provided, the recourse to that would, on the first instance, be that of the employer. So, what is the legal recourse? What is the legal cost that you're going to bear? The POSH committee complaints inquiry and the whole investigation has to be done by the employer. If there is a civil suit or a civil complaint that's to be filed, say against a person for any damages, now that is something that a seafarer is wanting to proceed on his own. It's something that the ship owner has to decide. Similarly, if there is a criminal proceedings that the seafarer wants to proceed for assault or bullying of any form, including sexual harassment, etc., that is a tricky question. But in my opinion, it is something that would ordinarily first the seafarer is going to look to the ship owner. It is something that could very well become a part of your P&I cover, and that's something that you can consider.
No, I asked this because both parties may belong to the same owner. So, where do you go in that instance? Because both the
Yeah.
offender and the victim would be part of the vessel, right? So,
Yeah,
it's a
which is
little bit
where, yeah,
complicated.
I agree. Yeah. But for the most instance, the investigation, etc., is borne by the ship owner. It's only when it goes
Parties.
outside the investigation scheme into that of a civil action, either in a court of law or a criminal action. That's when it would then we'll have to see where it goes.
I think a lot of videos have turned up now. So I guess we should take a few more questions. because this is something very complicated. When it comes to costs, everything just goes out the
Indeed.
window. Costs come into the picture, so
Indeed.
it's a
Yes.
major deterrent for all of these things. So I think we should get opinions from the members of the audience.
And stakeholders, yes, of course.
Yes, yes.
But a little quickly, if you don't mind.
Yeah, we have just another, I think, 2-3 minutes more if we could take any more queries. And I would also request all to turn on their videos as well. We plan to take a snapshot as well. So yes, thank you all. Any more queries?
Okay,
Okay.
since there are
If
no
not,
more queries, with
yes,
President Jimmy's permission, I'd like to formally
please,
deliver the vote of thanks. On behalf of
please.
WISTA India, I extend our sincere gratitude to Advocate Priya for an enlightening and thought-provoking session on employment law and workplace safety in the maritime sector. Your insights into the legal and human dimensions of POSH, harassment, prevention, and inclusion, both on shore and at sea, have deepened our understanding of these critical issues. A special word of appreciation to all our members and participants for taking the time out to join us this afternoon. I would also like to thank President Jimmy and the organizing team for their meticulous planning of this seminar and the seamless execution of the same. Together, let's continue to promote a safer, more inclusive, and equitable maritime workplace. Thank you once again and have a great evening. Thank you.
Thank you, Aarti. Thank you. Vaishnav, were you able to take the snap?
Yes, Jimmy, that was done.
It's done? All right. Thank you all very much. And hopefully we'll see you again for the next session. Yes, thank you.
Thank you.
Thank you, ma'am.
Thank you, ma'am.
Thank you.
Thank you so much.
Thank you.